Number 45, People versus Joel Nelson.
Good afternoon, Your Honors. My name is Alexis Asher. I'm from Appellate Advocates, and I'm here on behalf of Joel Nelson. I'd like to request 3 minutes for rebuttal.
You may.
Thank you. The trial court in this case failed to ensure that Mr. Nelson had a fair trial. He failed to do anything about 4 days of a 5-day trial of spectators walking into his courtroom wearing very noticeable white T-shirts with full-length photograph of the deceased.
How do we know they're so noticeable? Does anybody say they're that noticeable? I mean, some people did notice them, but there's conflicting. I mean, the only thing we really have in the evidence in the record is what the judge said, and he seemed to conflict with himself at times. But how do we know it was so noticeable?
Actually, we have what defense counsel said. After defense counsel was done delivering his summation, he requested a sidebar, and he said, this is page 297 of the record. Oh, excuse me. Yes, it's page 297 of the record. He describes the shirts, and he says, Judge, there's 3 members of the family sitting as close to the jury as you can get in clear view. That's what defense counsel said. He described the shirt. He said it was a full-length photograph of the deceased, and he was able to read the caption. The court, in response, was able to read the caption of the shirt from his vantage point. The prosecutor never said, Judge, I don't think the jurors can see the shirt. The court never said, I don't think they can see the shirt. The court said, I've seen these shirts for 3 days.
What if they could? Is it inherently prejudicial to have a shirt with a photo of somebody? It doesn't say, get the murderer or anything inflaming the jury, but remembering, that's what it said, right? Remembering, and then
Yes.
had his name on it. Is that inherently prejudicial?
Absolutely, hands down, inherently prejudicial.
What if there was only one person in the room for 5 minutes with that?
That's a different case. It depends. It depends on the circumstances of the case.
Not too long ago, there was a case in which a correction officer was killed, and routinely every day during the trial, his fellow correction officers came in uniform to watch the trial. Is that inappropriate?
It can be. Different courts go different ways. Lots of judges let that pass. Some judges take preventive action as soon as they see it.
I'm asking you because you say that these T-shirts are clearly prejudicial. I'm just asking if, there's this show of force, so to speak, in support of the decedent, if that is inherently prejudicial.
I will say it can be, yes. The reason being because just like these T-shirts, and these T-shirts are a step above that. This is a photograph, again, of the victim. This court said in People v. Stevens, you can't put a photograph of a murdered victim in as evidence,
Counsel,
Mr. Prosecutor.
is there a difference if there is a family member of the victim of a homicide who is crying in the courtroom during the course of the homicide trial? Do we draw a line there?
That's a different story.
How so?
When you have a murder case and you have, obviously somebody who's no longer with us and family members come and they're grieving and they're showing it, that's part of a trial. That's part of what happens. If it gets to be out of hand where, that family member can't control themselves so it gets up and starts yelling.
Playing a photograph of a victim's family, a victim, is that a form of grieving?
It's taking it a step above. Again, we have the photograph and we have the text. This was a plea to the jurors to please find him guilty. We believe he's guilty. Find that he's guilty. Even if it was just of grief, even if they just went in there and they didn't realize what they were doing as they sat with each other as a group in front of the jurors on this critical day of summations in charge, even if they were just grieving and they thought they had the right to do it because nobody here stopped them, that's not okay. That's expression that does not belong in a courtroom.
Let me just ask you, you mentioned that the judge noticed that before counsel brought to the judge's attention. So are you saying that the judge had to do something about it before it was brought to the judge's attention by counsel?
Absolutely. This is his courtroom. The rule we're looking for is that as soon as the judge sees some sort of spectator display in its courtroom, it has to do something about it. You have to assume that those jurors, who the judge should be protecting from any outside influence.
Counsel has to do something about it, but wouldn't that depend on what it is? I mean, what's the test that we're applying here?
The inherently prejudicial test.
So it's inherently prejudicial, that's it, reversal, they saw it. no test, the judge applies. I saw someone with a T-shirt, I think the jury saw it, mistrial.
It depends on the facts of the case.
Right.
If the display presents an unacceptable risk that those jurors are going to consider
That's the second
it.
part, right?
Right, then that's what we're dealing with. This case,
The judge didn't think that it did present an unacceptable risk. The judge really laid it out and said, you know, they're not acting out, they're being very quiet, they're sitting quietly. You know, there's only a couple of them. Maybe it was covered with jackets, maybe it wasn't. I don't know, but so the question is do we look at that and ask whether that was an abuse of the judge's discretion? Is that what we're looking at?
the judge here made a conclusion that these shirts weren't inflammatory. These shirts are exactly the kinds of things that factor into the jury's consideration of a case. They have family members sitting in front of them. The law review articles that we cited have the science that says these are exactly the type of things that influence the juror's verdict. So the judge couldn't sit there and say, well, I don't think these shirts aren't inflammatory.
So we would have to say, as a matter of law, and these were inflammatory. And then what's the next step? Don't we have to analyze what effect that may have had on the jury?
Whether this was an unacceptable risk that they would have considered it.
And then we would have to find, as a matter of law, that he abused his discretion in not sending them out of the courtroom?
He had a duty to make sure that the jurors did not see these shirts for 4 days out of a 5-day trial, and he did nothing. I remind this court in People v. Stevens, as I said before, this court already said a live photograph of the victim is impermissible at trial because it arouses the jury's sympathies and resentment. Well, imagine how they felt
Different when
here.
a prosecutor puts a photo into evidence. Isn't that different analysis?
Sure, it's a different analysis, but it's the same point. You don't want that in evidence, and this court has recognized it, because the jurors might be influenced by it. Now, in my case, you have family members wearing this photo with text, remembering Leo Walton. Do something. Find him guilty. This...
Wait, does the court have to ask the jurors if this is affecting them, or what does the court do to do something about it? You just assume it affects them and then ask them to cover it up or take off the garment?
Absolutely nothing the jurors could have said, even if the jurors would have gotten up and said, well, I don't think it would have influenced me. At the point we were in this case, the 4th day of a 5-day trial, there's nothing that they could have said that that would have taken away what happened in this case.
So there's no need to question the jurors. The judge just assumes that it's prejudicial and does what?
Tells them to take the shirts off, and that should have happened the first day. The family member, the first
Do they have
family
to be
member.
preserved? For the first 4 days, let's say it's partially preserved, at least there's an argument, there's discussion on the record, the judge makes a ruling, counsel doesn't clearly object, but he seems to object. So let's just assume it's partially preserved from the end of his summation on. That's clearly seems to be preserved. What about before that? Does that need to be preserved?
Our argument is that it is preserved.
So?
Because when defense counsel protested, he protested to what he knew. He only knew of the jurors on that particular day. And then when the court...
So following loosely, back on Judge Fahey's point, is this court's review of the question of law that's raised here limited to the facts that are in the trial record and not the post-verdict motion?
Well, everything is in the trial record. The post-verdict motion sort of just elaborates on where these jurors were sitting. But
So answer my question. Is our review limited to what's developed on the trial record?
no, it's the entire record on appeal, which would include the post-verdict motion and the comments that were made at sentencing.
Is it subject to harmless error analysis?
Absolutely not, because this is a fundamental due process violation. In a courtroom, you have a judge who's supposed to control what goes on, and an impartial jury, and when you already have spectators coming into the courtroom to influence the jury with silent speech, specialized clothing, these weren't just grieving family members. They decided what to wear that day. They decided where to sit. And the record is also interesting because it appears that there were other family members on that day who were there to support Leo Walton's family, but those who were wearing the T-shirt went and sat closest to the jury. This is a fundamental thing. When we say you have a fair trial, it's supposed to mean something. The judge is,
But if a defendant is shackled, is that subject to harmless error?
yes, but shackling is a completely different...
How is that completely different? Doesn't that clearly plague that the state is suggesting there's something violent and terrible about this defendant versus just having a T-shirt that says, "Remember my family member who's no longer here"?
Shackling sends a different message. First of all, sometimes you can constitutionally shackle a person in front of a
Understood.
jury, right? You can do that. That's permissible. You can never have spectators come. You can never say, Your Honor, I'm going to have the spectators come. Okay, that's never it should never be constitutionally permissible. Shackles can send the message to the jury that, the charges are dangerous. That's why he's shackled. It makes sense. But when you see these shirts, that's a message. That's
What if it's
pulling on the
one per-
heartstrings.
One person with a button, maybe 2 inches in circumference, and the same thing, and it has a picture, and it has some words remembering, Leo Walton. Is that, and there's one person sitting in the courtroom in the front row or the second row for counsel summation. Is that inherently prejudicial and not subject to harmless error analysis?
Again, that's a different story.
I
However...
like that. We're trying to figure out where the
Yeah,
line
no, of
is.
course. If it's clear to the judge that that's a photograph of Mr. Walton, and if it has text on it like it did here, and if they're sitting next to the jury, yeah, it's error. If defense counsel didn't know, and if they had been wearing it for 3 days on top of it, and the judge never even tipped them off, that's an even bigger error. And in this case, it's reversible error, because it permeated the trial, and we can't say that those jurors weren't affected. This was the appeal to convict.
Anyone wearing the button in there and it gets in the courtroom and it's there for, let's say, 15 minutes, it's mistrial.
It's error. Whether it's reversible error, again, you have to look and see, well, is this the kind of unreasonable risk that this infiltrated the jury's deliberations?
Judge in the best position to do that.
Not necessarily, as Mr. Nelson's case shows. This judge should have tipped off defense counsel that these shirts were being worn day one, and he didn't.
But as a general matter, isn't the judge in the best position to see what's going on in the courtroom and make a determination on the second part of this analysis, which is, what should I do here, if anything?
He has to do something. Yes, the judge has to do something. I think maybe we agree on that. The judge has to do something about it. Even if he determines that, I can't see it, let me call up the parties. Let me tell the attorneys, look, I think I see a T-shirt back there or a little button or a ribbon. I don't know what it means. I don't know if I can see it. Make your record.
It's the fact that he didn't do anything here.
He didn't do anything, and again, the message, the content, these shirts. This was a huge display of emotion. This was a photograph and text and a group sitting as close to the jury as they possibly could get.
Did the judge need to advise counsel at the very first occasion upon which the judge observed someone with the T-shirt?
Absolutely. This has no room in the courtroom. He should
Thank you,
have...
counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. May it please the Court, my name is Morgan Dennehy. I represent the respondent. The judge did do something here. He gave the jury an instruction. He told them to decide the case on the evidence and not on emotion. That instruction goes a long way. This Court and other courts have
So
routinely held that...
regardless of the display, as long as the judge says ignore that, that's good enough?
It's
But it'll always cure, the instruction always cures?
Well, it depends what the display is. I mean, these, as the appellate division correctly, the majority correctly observed, and actually the dissent agreed with the majority, that these spectator display cases are to be taken on a case-by-case basis because there's so many different permutations that these cases can take. It's very fact-based.
The difference is that it's a spectator? In other words, would you agree that if the prosecutor wore this T-shirt, that would not be acceptable?
Well, that's a state actor, and I think state
I'm
actors...
asking you, it's the difference that it's the spectator? Is that what makes the difference? It's the family members in this particular case?
Yes, absolutely. And they can come in with various forms of showing their grief, the crying mother. And it's as Justice Garcia mentioned, the trial court's in the best position to determine how inflammatory and how prejudicial these displays are.
So you would agree that if the T-shirt had the picture and it said his name on it and it said, convict the killer.
That would be a much
That
would be a worse T-shirt. I would not concede that would give rise as de facto due process violation. It depends on various factors. And that's why the test that's been articulated by the United States Supreme Court is so nebulous. It's an unacceptable risk of impermissible factors coming into play. I looked at that a couple of times and didn't quite know what it meant, but it leaves room for a case-by-case analysis considering different factors. And if I could suggest that this is what the court should decide in this case, is that these factors should be considered, and the appellate division touched upon this, and the factors should start with the nature of the display. How big is it? How is it being displayed? What is it? In this case, it was a photo of the deceased with the words, "Remembering Leo Walton."
What if it had said Justice Ford Leo?
That would be worse. So that would be a factor that would suggest prejudice. But in this case, we don't have that here. Other factors, how many people are wearing the display? Where are they seated? For how long are they wearing the display? All of these factors are taken into account in determining whether or not that there's been an undue amount of prejudice in this case.
Whose obligation is it to make a record of all this? Because, it's a fairly skimpy record, I think, in terms of...
And that's, I don't want to gloss over that point, Your Honor. The record in this case is completely inadequate to determine what, if anything, the jurors saw. The defendant is alleging a due process violation, but we can't tell from the record...
Can we take the judge at his word?
Absolutely. I think the
And
judge...
what does he say?
Well, the judge there were two opportunities to discuss this issue. Once, when the objection was registered right after defense counsel completed his summation, right before the prosecutor began his. And the judge, I think, was a little taken aback by the timing of the application made by defense counsel. He thought it was a little suspicious that these shirts had been being worn previously, but counsel...
Isn't that what he says? Someone's been wearing them for several days, plain, I saw it, I know it said remember Leo Walton.
That's right.
Picture. I mean, the judge puts on the record exactly what the display is,
But
how
the
often.
fact that he can see it from the elevated position on the bench in the middle of the courtroom does not mean that the jurors can see it from the side of the courtroom. And opposing counsel keeps saying that these spectators were sitting right next to the jury. The only evidence in the record of where they were sitting is the second row.
But the judge was particularly upset because he expected that the defense counsel floor level to the jury, right?
Well,
Didn't see it, or
that's a
claimed
presumption.
not to see it, right?
I still think, because we're guessing about all this, I think it makes my point, that really the record, there's lots of holes in the record with respect to the nature of this display, the length of the display. And speaking of the length of the display, I'd just like to make this point very quickly. My opponent argues that the pre-objection display of these shirts goes toward the claim, the due process violation claim, but that aspect of the claim is not preserved. Counsel, when he made the objection, he asked for specific relief. He asked for the removal of the shirts going forward. And that's what's at issue on this appeal, not the prior wearing of the shirts. He didn't object to that at all. And he was informed, even after he was informed that there was prior wearing, he said nothing.
How would he object to it if he didn't know it? He'd move for a mistrial?
Absolutely. He would say, Your Honor, you mean to tell me that someone was wearing these shirts on other days? Well, that's extremely prejudicial. I'm moving for a mistrial. And that,
Even though the court had made it very clear that he wasn't buying it.
well, it didn't obviate the requirement that counsel actually make the application. Taking...
Counsel, I'm sorry, just so I'm
Yes,
clear
sir.
on that prior point, when you said he instructed the jury, that was the standard instruction, right?
It was standard, but it was effective, and jurors are presumed to follow instructions. And it was very specific. Again, also, defense counsel never asked for a more specific instruction to specifically mention the shirts. So the court's failure to actually make a more specific instruction is not error. And really, the court, sua sponte, shouldn't have done that because that's really a judgment call on the part of defense counsel.
Well, and that might even bring more attention to this shirt.
Correct. That's why the court shouldn't have done it on the court's own. I'd like to touch upon harmless error. If this court concludes that the wearing of these shirts...
Before I move on, should the judge, upon the first observation, should the judge have informed counsel or asked counsel
the court
whether or not there was any problem with this?
The court
Or
never...
not at all?
The court never brought it up.
No, I know that. That's
Yeah.
not my question. My question is, should the judge have done that? Does the judge have any duty or obligation other than to make a determination as to whether or not this is prejudicial?
If the court saw the shirts and concluded that the shirts were fairly innocuous, were not inflammatory, were not being displayed in a flagrant manner to the jury, and therefore that no prejudice was resulting, or maybe there was some prejudice, but it would be ameliorated by the instruction, then the court is under no obligation to bring that up.
If that's a ruling that the court is making, should the judge have put that on the record?
Only if defense
Then none of
counsel...
us are speculating about it.
Only if defense counsel objects to it. Because
Well, he wouldn't have known until the very end, right? So that we were going to get back to your other point. At that point, he should have objected, and and then the judge should have said, I made a ruling on this?
Well, the court,
Is that what you're saying?
the court could have made a better record. Again, I think the court was taken by the timing of the objection. And I think the court did make a better record when it was after a couple of days at the sentencing proceeding, when the 330-30 motion was made. The court made more detailed findings and
Can you think of any reason why the judge, I mean, I know the judge thought that there was some tactical thing, but can you think of any reason why the judge wouldn't ask them to cover it up?
I think the better course, if not for any other reason than it would take away this issue for an appeal, we wouldn't be litigating right now, would be to have the
Sure, but can you
the
think
family members
of
cover
any
up.
reason not to, especially when asked?
I think the court was respecting the deceased victim's family's right to grieve. And I think the court...
Is that the judge's duty and obligation?
I'm sorry?
Is that what the judge's role is in that courtroom, to concern herself with the family's needs?
No,
Or
but
the
the court has
defendant's
to-
rights in a fair trial?
Obviously, the primary obligation is to ensure the right to a fair trial, but the court obviously thought, and correctly so, that the Schertz didn't infringe upon that right to a fair trial. And so the court wasn't going to ask family members. I mean, this was a crucial juncture in the trial. The court would have had to excuse the jury, inform the family members that they had to leave the courtroom, go into a bathroom, take off clothing. I mean, it was awkward.
So are you suggesting the court doesn't have an affirmative duty to take steps to control the decorum of the courtroom?
I'm not suggesting that at all. The court absolutely has that duty, and I think the court exercised that duty here correctly. Again, it's all dependent upon these factors and the nature of the display. I won't go into them again, but in this case, considering all the factors, the display of these shirts for that limited period of time, we're only talking about 2 hours or so, 2.5 hours during the prosecutor's summation in the court's charge, the continued wearing of the shirts did not result in a due process violation. Very quick.
Even if it were awkward, counsel, but defense counsel was asking for that, that would have made it awkward for the defendant, but defense counsel was asking that the court actually send these spectators out and have them change their clothes.
That's right. That was the application.
Right. So why was that awkward? That's what I don't understand.
Well, at that particular juncture for the court to say, okay, we're stopping the proceedings, jury, please wait outside. I know it was a slight inconvenience, but it's relevant to consider the context in which the application was made. And the bottom line is the court didn't think it necessary because the court...
Well, I suppose, though, it seemed to me, reading into the record, like the court was treating it as if the court had been sandbagged. This has been going on for a number of days. You didn't object, and now you're objecting at it right before the people are going to do the summation. So that's what came across in the transcript to me.
That's part of it, for sure.
That's probably I maybe read a little bit more into it, but it seems to be that was part of it.
I also...
Of course,
yeah.
that'd be error. That'd be error. The court shouldn't make a decision that way. So the question is at this point, where it hasn't been objected to before, is it harmless error if we go forward from there?
It absolutely is harmless error. There's no question about the applicability of harmless error. Deck v. Missouri, United States Supreme Court case, said that harmless error is applicable to shackling cases, and this court has obviously adopted that rule in 3 recent cases, which I cite in my brief, Clyde, Best, and Cruz. So there's no question that it applies to shackling, and if it applies to shackling, it has to apply to this kind of error, because shackling is much worse. It's much more prejudicial. There's state actors at play here, shackling a defendant, and I think shackling, the message that shackling sends is way more prejudicial to a defendant than a grieving family honoring their deceased loved one. So I think if it applies to shackling, it has to apply to spectator conduct. And the evidence here, this is a textbook harmless error case. This was not a close case. The evidence was overwhelming. This defendant made extensive post-arrest statements claiming self-defense that could not ever have been true. It was flatly refuted by the ballistics and the other evidence at the scene, which corroborated the account of the surviving victim. Just not to belabor the facts, but I'd like to just point out these couple of quick facts. The defendant claimed that the deceased victim was shot by the surviving victim and when he came in the room and fired wildly. Well, the deceased victim had 3 bullet wounds precisely placed in the back of his head. He was killed execution style. So he couldn't have been killed in the manner in which the defendant described in his post-arrest statement. Also, he claimed that he was simply defending himself against the surviving victim, yet the surviving victim testified that the defendant kicked his door in and began shooting at him, and he hid behind his closet door, and that saved his life. Actually, the surviving victim got shot numerous times. And the evidence showed that the door frame on the bedroom door of the surviving victim was splintered. Someone had kicked it in, and there are numerous bullet holes in the closet door, exactly where the surviving victim said he was hiding. So this wasn't, the jury returned a very quick verdict in this case, and it wasn't because of that they potentially saw these T-shirts. It was because the evidence was overwhelming. So for all of these reasons, this Court should affirm the decision of the Appellate Division.
Thank you, sir. Counsel?
In People v. Crimmins, this Court carved out a category of cases in which a due process violation occurs and harmless error does not apply. That is because, and I'm quoting, "The right to a fair trial is self-standing and proof of guilt, however overwhelming, can never be permitted to negate this right." So what we see when we have cases in which there's spectator conduct, and now I'm speaking of the Supreme Court cases that are cited in our brief where you have the media coming in, you don't look at the strength of the evidence. You don't look to see whether the evidence was overwhelming, notwithstanding the spectator display. What you do is reverse a conviction because it's that bad. Due process means that Mr. Nelson should have gotten a fair trial that included not having these spectators in the courtroom. It also means that the public should be assured that when those courtroom doors are closed, what goes on inside is fair. The judge is looking out for his jurors, the judge is looking out for his defendant, and we don't have that here. Anybody who walked into that courtroom, especially on the 5th day when the prosecutor was delivering a very powerful summation, standing in what I presume wasn't in front of the witness box, but more in line in front of the spectators, and saw the prosecutor with the backdrop of Mr. Walton's family wearing their T-shirts that were very clear, the Court described them from his vantage point, would not have let that courtroom thinking that was justice. Justice means justice, and it did not happen in this case.
Let's say we disagree on, and determine that the harmless error analysis does apply. Why isn't the evidence of, as already described, sufficiently overwhelming? Why doesn't it meet that test?
The evidence was strong. However, you cannot parse through the verdict and decide, well, maybe the jury reached that verdict for these reasons. This jury was inundated with the image of this victim's family sitting there begging for a conviction. And just my last thing, I see my light is on, is that everyone, well, I'm sorry, the prosecutor keeps saying that, you know, the record is specious and it's not adequate and we don't know. We do know. We know how many times the spectators walked in the courtroom. We know what the shirt looked like. We know what the caption said. We know who was wearing them. We know where they sat. We know what the judge thought of them. This record is perfect. You don't see better records than this in a spectator misconduct case. If the Court has no further questions, thank you.
Thank you.